Welcome to another, I started to say video legal pad, but that's not the right thing.
That's not right.
It's a webinar. Welcome to another webinar with Vann attorneys. We're really glad you're here. We're going to be talking about breach of contracts today. Jim Beck and I, my name is James Vann. We're going to be leading you through some topics that we see quite often with breach of contracts. Before we get started, a little bit of homework. If you have a question and you want to submit it, you can use the control panel on your screen to enter it that way, or you can send it to us by email at webinar@vannattorneys.com. So again, thank you for attending. And again, if you have a question, we'd love to hear from you, because more than likely, if you've got the question, other people do as well. So breach of contracts, right? We see that quite often, and we help a lot of you with those. We're going to be looking at what is a breach, a minor breach versus a material breach. What is the difference, and how does it work from a legal perspective? We'll be talking about damages, unfair and deceptive trade practice claims, as well as questions about signatures on the contracts. So before we get started with that, I want to mention one other thing. We're going to have our next webinar on April 21st, and we would love for you to be a part of it. It's going to be an awesome webinar. We're trying to narrow down the topics now. So if you've got one that you want us to include in our webinar series, please let us know. We'd be glad to try to work that in. So again, that's April 21st. Okay, so essential elements for breach of contract. What does that look like? So in North Carolina, and everything we're going to be talking about today has to do with North Carolina law and as it relates to breach of contract. So in order for there to be a breach, right, there's got to be a valid contract that exists. And a valid contract would be one that's lawful and legal versus being something that would be an unlawful contract. Carrying out maybe a criminal action or maybe some of that nature, but a valid existing contract. There's got to be a breach of the contract, and there's got to be a proximate cause of the breach to the contract. So there's got to be a relationship of the breach with the contract. And then fourth is there's got to be some damages that are due to the party that did not breach the contract. And Jim, I know we see quite often people will call us or we'll talk to our clients, and there may be a breach of the contract, but there are no damages, right? Nobody got hurt. There's no loss. And what do you do, right? There may be some elements to that we can help people with, but sometimes it's just one of those things of, oh, well, yes, it was a breach, but thankfully there's no damages to it. So
I got a call today, same thing. Homeowner entered into a contract, the other party messed up. The homeowner had never paid the other party, and so my question was, well, the other party hasn't asserted that you breached it. You didn't pay. You're not out any money. So why do you need me? There's not a claim yet. There's no issue. There's no damages. So it's kind of essential that for there to be a breach, there be some damages.
You know, a lot of times people will call and they'll have there's clear a breach of contract, but again, or someone didn't carry out the contract exactly to the small details of it, right? Is that a breach? Could be, but again, Jim's going to lead us in conversation in a minute about material breach, right? So Jim, talk to us a little bit. What's the difference in like a big breach, a material breach, or a small breach, or how does that work?
Well, the case law calls it a breach of the heart of the contract, and all that means is, what's the contract about? Was the contract for one party to provide a good or service? And it would be a breach, a material breach, if that contract was entered into and that party did not provide the good or service. It's pretty basic. So the court's going to look at, okay, what really happened? What was really the actual issue that caused this breach? So a material breach is where the breach causes the non-breaching party to receive something different from what the contract promised, and substantially defeats the purpose of the contract, or is basically a substantial failure to perform. And that would be a material breach. And there's some factors to consider here when you're talking about a material breach. What was the subject matter and purpose? Again, that's what the court calls the heart of the contract. What did the parties intend? What was the scope of performance that could reasonably be expected? And are there prior dealings? And they look at that to say, okay, well, let's say we've had a relationship in the past where certain things were provided a certain way. Entered into this contract, they provided those things the way they've always provided them. So if you then claim a breach because they didn't comply specifically with this particular contract, these prior dealings might make that a minor breach instead of a material breach. So again, when you're thinking of a material breach, something that is significant in that the real purpose of the contract was not carried through. Think of it something major. I'll go back. I didn't know if there was another slide about this, but the minor breach, on the other hand, think of it as a situation where they might have done something inconsistent with the contract, but for the most part, they carried out their responsibilities. And one example would be you hired a contractor to put a deck on the back of your house, and maybe they put the stairs on the wrong side. Well, that would be what would be considered a minor breach. It wouldn't be a material breach of the contract. It would be something they might need to correct, but it's not something where you can say they didn't perform under the terms of the contract. It doesn't rise to the level of defeating the purpose of the intentions of the party.
And I think that's what about the courts look to is the purpose, right? What's the general purpose of the contract? What purposes? And sometimes we get people calling and they just are trying to pick a fight, and they it's the really small minor stuff. Well, they didn't do like these 10 things exactly what they were supposed to, but overall the purpose of the contract was carried forward. So you got to think through that. I mean, sometimes just the emotions that are in it, and it makes sense, right? But it may not be legally right.
Right, and another example might be contract says you have to deliver these goods by the 3rd day of the month to a particular location. You have no prior relationship or no prior dealings. Maybe the reason that material or good need to be produced in that way and delivered in that time frame would be it's a vital part of the underlying contract for whatever the project is. And if you're late, it causes the non-breaching party to breach their contract with who they dealt with. On the other hand, if you had those same terms, you've dealt with this this customer for years, always had that similar term in the contract, and there's been a sort of a 3-day window that you've always complied with, maybe that becomes a minor breach because you're looking at prior dealings and how they've operated throughout the course of the relationship. And did it really have a impact on the non-breaching party that defeated the purpose of the arrangement?
Yeah, that's a good point. So let's look at a term that's called anticipatory repudiation, and that's, I don't know if those are legal terms as much as they are just terms that we don't normally use every single day. But what does that mean? So legally, and if you have a situation where a party to a contract, they refuse or to fulfill the contract, or they discharge a contract obligation with respect to performance that's not yet due. That is, for some reason, they say there's a communication of your intention not to perform. So you have a contract with your customer. Customer says to you, "Hey, look, I know we have this contract, but I can't do it, or I'm not going to do it, or I don't have the ability to do it." But they demonstrate a clear determination that they're not going to continue with the contract. They could have already started, or maybe you've signed it, but the performance hasn't started yet, right? Or it could be halfway through, it hasn't finished it. The action must substantially impair or impact the value of the contract in its entirety, primarily to the other non-breaching party. So if that happens, that's called an anticipatory repudiation. But you're anticipating that they're going to back off and not perform the contract terms. And then and it's closely tied to this. The next term is adequate assurances. What is that, right? It's really tied very closely. So a party who has a reason to believe that the other party is unwilling or unable to comply with the contract terms can ask the breaching party to provide adequate assurances. So, for example, if you think the other party is going to do the anticipatory repudiation, they're going to back off the contract and not perform it, you could ask for adequate assurances to say, hey, I need to tell you need to tell me whether or not you're going to fulfill this contract, either finish it or fulfill it, whatever status it's in. You have to send it to them in writing. You have to give them reasonable time for them to respond. Typically, that's 30 days. And in some circumstances, in some industries, like we've helped some industries in food groups, where 30 days and all of the goods could be like rotten. So 30 days may not be typical or reasonable in that context. And there could be other circumstances where 30 days should be, that's just too long. You have to have something shorter. But if you don't get a response, or they say, yeah, you're right, I'm not going to perform this, then you can go forward and try to have somebody fulfill the contract. And of course, you can charge the breaching party with the extra cost. But if you don't have a response, then the repudiation of the contract is established. So, and for example, you would use that in this case if it's 30 days is reasonable, if the performance of the contract normally would be 30 days or out, right, further out. If you think they're going to, for example, when the economy is maybe not bubbling as warm as it is right now, I know we've had people call and go, hey, look, I've got this contract. They're supposed to do, X, Y, and Z, but their equipment is, they're starting to sell equipment. We are hearing in the grapevine that they're going to close up. What should we do, right? So this is an opportunity you could write them and ask for adequate assurances. And there are some statutory requirements. We've gone through most of them here. But if that happens to you, we would encourage you to call us or call another attorney and talk to them and say, hey, look, help me make sure I get this writing to my customer or to the contracting party and make sure it's correct by statute so that you don't have to worry about that going forward.
What if you send them the notice and they say, no, we're not going to perform? Is it then a breach?
Yes, at that point, that's a breach of the contract. That's right. And, then that part, it sort of frees up so you can go forward and do what you need to do to get the performance you needed from someone else. Yeah. What I thought you were going to ask another question. What happens if they go, no, yeah, we're gonna perform, and then don't, right? It's still a breach. And
yeah, I think maybe then if they don't commit to a date, maybe you look at the contract and say, what's the time frame for performance? Right, yeah. And they may be in breach anyway.
A lot of times, I know we've helped some clients with this. We say, hey, look, we need to have this in a certain amount of time back, and we need to know your schedule going forward so we can make sure that compliance of the contract terms are going to go forward. And again, it depends on what the purpose of the contract is or what the schedule or time frame is, whether or not how you would do that if you need to do it, right? But you need to have those assurances, adequate assurance that they're going to be able to comply. And then what are the damages? So we talked a little bit about damages in the very beginning, but you have to have damage. That's an element of the contract, right? For breach of it, you have to have damages. And so it could be specific performance, and that is, I want to make sure that, this is not necessarily a dollar recovery. Let's say, for example, that, you are going to sell a bike, right? So a really special bike, right? Some fancy, bike riding equipment on it, that kind of stuff. Well, I'm going to sell that bike because it's really special. You could buy that bike somewhere else, maybe, but if this one's like really, really special, designed for a special particular ride or whatever, if I backed out of it as a seller, the buyer may say, no, we had a contract. I want that bike. I want specific performance to say, you need to sell me that bike. Don't buy me another bike. I want that one. Or money damages wouldn't be enough to make me whole. I want that bike because there's something special about it, right? Money damages could be, and a lot of times are, the recourse that most people go to for breach of contracts. It's the direct, natural, and proximate result of the breach, right? So how much did it cost the other person or other group to cause the other party breach? Restitution, that is making them whole, right? Restoring them back to where they were. Again, it's probably going to be money for the most part. Rescission is a cancellation of the contract and return the parties to the pre-contractual status. That is, we're going to rescind the whole contract, put everybody back where they were initially. We had this one time before. There's two individuals fighting over property, and they each had some property of each other's, and it was just getting to be really ugly. And we were able to go back and say, you know what, let's just unwind it all. Everybody get what they initially had back and solve it back that way. And it actually worked out. But that would be a cancellation of it and then getting everybody back to where they were pre-contractual status. Another form of damage would be liquidated damages. And that's the sum where the parties to the contract agree ahead of time. That's when they're writing the contract, what the damages might be if there is a breach. And that's pretty unusual for the most part. I mean, you don't see that. You might see it in construction settings a lot, and maybe some other situations, but liquidated damages is a time where you predefine what the damages would be. Nominal damages, it's a trivial amount. It's award due because there is a breach, but there's no real actual loss or injury. We don't do a lot of cases in court with juries now. I mean, there's some still, but not as many as there used to be. And I have heard of some Wake County juries where they have like $1 damage, right? Yep, there's a breach, but we're going to give you $1. Well, that's nominal damages, all right. So punitive damages is the other one. It's not typically allowed for a breach of contract in business by itself. There has to be some other issues that would cause punitive damages. But it's punitive in nature. It's to punish the other side. And I know people call us a lot of times in some business cases, not our folks that probably are tuning into this and listening today, that, I want to get punitive damage for this. Well, I know you're mad. I know but may not be applicable in the business course, right? So some of the situations that we get quite often now, people call or you look at a contract and you think, okay, that looks legit, everything looks straight up, and then you find out that there's something questionable about signatures on the contract. And so some of the questions we come up with is, did you have any idea, or did you know about the signatures? Are they forged, right? Are the signatures notarized or witnessed? Did somebody on your staff see the customer sign? We have used handwriting experts, and I'll tell you, every time we've used a handwriting expert, I love it. I mean, it's just, I guess it's always worked out for our client too when we always use a handwriting expert. And it used to be, at least when I first started practicing, handwriting expert, you need to have the actual paper, right? If you take it back, if you had the paper, you got better evidence from the handwriting expert.
Yeah, a lot of times they'll say, if you don't have the original, I can give you my opinion, but also they'll actually say in their report, it's inconclusive, I didn't have the original. Right. And today with all the electronic signatures and the way documents are stored, you typically don't even keep an original. Yeah. It becomes a lot more difficult to deal with a forgery issue. So it's definitely changing.
Yeah.
Because anyone could electronically sign a name on a PDF and then later say, well, they forged it.
Yeah.
Well, so it is a challenging subject matter.
The few times that we've had handwriting experts used, it's been fascinating. One time in particular, a little bit of a war story, the handwriting expert wanted to take the original back to their office, and we had not used this expert before, and I was like, I'm not willing for that to go out of our possession. So we sent one of our, I think one of our attorneys or the law firm, which to their office, and the handwriting expert took the original document and vacuum sealed it in over some plastic, and you could see the indentation where they actually signed it, and then they had actually signed stuff on top of it, like they were like 3 or 4 pages stacked together, and they were signing stuff. And that person was able to actually tell us what they signed, what their signatures showed. We had the envelope that the document had come back in. I mean, it was such a fascinating situation that they nailed the other side with. It actually settled really quickly after that. And then a lot of times they'll compare signatures now to stuff that's like on public record. But as we go into electronic signatures more and more now, that's becoming harder to do, like with deeds of trust or something of that nature. If you sign electronically, you may not have your signature there. That's going to be interesting how they work on that. But we just had a situation in another county recently where our customer had their customer and their spouse signed guarantees, and we had sued, got a judgment. They about 4 or 5 years later said, "Oh no, that, the spouse didn't sign that." They alleged that the husband actually signed the wife's signature, and I'm like, I'm not sure that I would do that, right? So if you look at the issues, right, that's fraud, right? So he was admitting in essence, he actually sued our client later in another lawsuit, saying that the wife shouldn't be a part of it, and it was breach of contract and fraud. And we're like, wait a minute, they were thinking we were part of the fraud. I'm like, no, the problem was the husband committed fraud. Mm-hmm. That case got dismissed, I think, a couple of weeks ago. It'll be interesting if they decide to come back, but that one just was clearly a mess, right? They alleged all these things that we did not know anything about and then never heard of. So in North Carolina, North Carolina considers almost any form of forgery as a felony because of the fraud portion of it. So the question is, how did the signature show up on the contract, right? Did it come to you by fax, by email? Was it mailed? Was it hand delivered? How did you get the contract, right? How did you get the credit application or whatever it may be? What's the knowledge of the parties to the contract? Did anybody on your staff see them sign it? And then is there with consent, right? Did one spouse sign the other spouse's signature with consent, or a business partner's signature with consent? So there are a whole bunch of things to look at, but those are some really questionable things that we see all the time. And thankfully, most of I think our clients, well, I think probably always have been in a great situation of not allowing questionable documents, right? That is, if their staff knows that a customer signed their wife's or their spouse's signature, they're not going to let that go through. They're going to stop that and get it fixed up right. So if you did have those kind of situations, it might lend itself to unfair and deceptive trade practices. So Jim, what does that look like in North Carolina?
Sure. Well, it's actually governed under a statute, and it's kind of vague sounding. It says unfair methods of competition in or affecting commerce and unfair deceptive acts or practices affecting commerce are declared unlawful. So they wrote it a little bit vague, in my opinion. So you then have to go and look to see how courts have defined what's unfair and deceptive and what kind of examples of conduct amount to unfair and deceptive trade practices. You got to get a couple of definitions here. Unfair means offends established public policy, as well as or a situation where the practice is immoral, unethical, oppressive, unscrupulous, or substantially injurious. I can't even say that word. Injurious to consumers.
It's not easy to say.
It's not a hard word to say, but still, I guess it's almost, you know it when you see it. I mean, what's immoral to what's unethical? Again, you kind of have to look at each case separately. And then deceptive just means it has a tendency to deceive. So we'll get more into all that for a little more clarity. Generally, a breach of contract is not going to lend itself to an unfair and deceptive trade practices claim. Courts are very clear there's got to be some kind of egregious or aggravating circumstance. And, it can arise out of a breach of contract with those circumstances present. And what I'm going to do is give some examples of what might be unfair and deceptive. So price gouging during an emergency. And these are things that courts have found to be unfair and deceptive. A builder making a representation that he could build something that he actually knew it would have been technically impossible to build in that particular location and size. It's a misrepresentation. So anytime you've got some kind of misrepresentation with knowledge that you can't do what you're saying, that can lend itself to an unfair and deceptive claim. A car dealer telling a buyer a car had not been in an accident when it had been in an accident. So again, you're making a misrepresentation. Fraud or deception when it arises to immoral, unethical, oppressive, etc. conduct. Couple more. So a contractor making a cancelable contract, but then refusing to provide the homeowner with the forms required to cancel. And then misrepresentations, generally speaking, by a seller to persuade a buyer to make a purchase. A lot of it results from fraudulent conduct, from misrepresentations, and just think of it as just a very shady business person doing something to either coerce or trick someone into entering into a contract, knowing that whatever he or she was telling that person was wrong. And it's just it's almost, think of it as you're just trying to trick someone into signing this contract to take advantage of them.
I read a case in preparation for this just recently. They were talking about where one entity sold multiple warranties to the customer, covering the same thing, right? It was obviously, if you look at the warranties, they're the same thing, right? They call different things, but it's covering the same thing. And they thought that was unfair and deceptive. It's usually a bad act, right? I mean, someone has a bad intent.
Right. Intent is a big part of it.
Yeah.
I think.
So I'm sorry. Go ahead.
You have a,
yeah. So we had a question come in. It says, can you breach an unexecuted contract where the claimed contract in question is either verbal or an email communication? Great question. So let me. I'm gonna sort of, and I would love Jim, you chime in on this as well. Right? Can you breach an unexecuted contract? Well, if it's writing and it hasn't been executed and there's nothing else, then no, because there's no contract yet and the parties haven't agreed to it, right? But you could have a written contract, no one signed, but then they say, hey, we're going forward, and they start.
You can establish a contract has been agreed to based on the conduct of the parties, even if it wasn't signed. So it's going to depend. I mean, it's really going to depend, but yes, you can.
Yeah.
I mean, it can be a verbal contract. Email can be considered a contract, right, if the parties are sent by email.
That's right. So we've had several seminars, webinars on this, where look, can you have a contract by email? Absolutely, right? No problems. And is that enforceable? Yes, it is. No problem with that at all. Can you have a contract by texting? Absolutely. There's two pieces of law. One's federal and one's state. One's the Uniform Uniform Electronic Transactions Act, and then e-sign, which is the federal one, which basically says any contract sent with electronics is considered to be a valid contract. It's just like you were going to have it in paper and blue ink, right? So that would still be valid. So let's just say that in that question, the terms, they've come up with a document, right, that they're waiting, no one's signed it yet, but like you say, Jim, they start carrying forward in their conduct to carry forward with the contract, and then they stop. Then, yeah, that would be a breach, because it's obviously the parties have complied with the contract terms up until the breach. Or if you have an email or text contract and they stop, still could be a breach. So I think that answers that question.
Yeah, another way to do that is you've got an unsigned contract and then the parties have basically agreed without saying, yeah, okay, I agree. But one party says, okay, get started. And then you go get started. And then the other party says, I'm not going to pay you. I didn't sign the contract. I think you have a breach contract.
Yeah.
It's always going to be a question of what are the facts in that situation. And they're going to look at the conduct of the parties and, that sort of thing.
One thing that we see quite often, thankfully not tons, but we do see it sometimes, and that's a truly verbal contract where there's no writing, there's no text, there's no email, there's nothing to go around. It's just what one person says versus what another person says. And I'll tell you, those are hard to prove because it's a he said, or she said, It's how do you prove what the terms are, right? I hate to say it, but I would almost say it's virtually almost impossible to be able to prove that with any accuracy, unless you have conduct or something of that nature. But outside of that, it's pretty tough. So I hope that helps.
So back to unfair and deceptive. To succeed on such a claim, claimant's got to show actual injury, and then the damages have got to be related to the wrongful act. I guess one of the reasons we bring this claim, as opposed to, we bring the breach of contract, maybe we brought a fraud claim, whatever. But the unfair and deceptive aspect of a claim will get the claimant, will bring in the ability to recover attorney's fees and treble damages. Treble damages are 3 times the amount of the actual damages. So it's similar to a punitive damages, but it's set at 3 times the amount. We actually had a case recently where it doesn't happen a lot. There's not that many cases that really get you there, but a party had let some third party use their credit account, then defaulted, didn't pay it, and the court granted treble damages, 3 times the amount. Not only does that increase your recovery and cover, the fact that not only you're out that money, but think about the time and the time value of money and all that, the costs. So that increases your recovery, your ability to recover. It's kind of a compensation for the wrongful act, and it definitely gets people's attention when, instead of, say, a $20,000 judgment, it's now an extra $60,000 plus attorney's fees. That might, increase your chances of getting this defaulting party's attention.
Yeah.
So,
and sometimes we see there's some lawyers across the state that always put in an unfair deceptive trade practices claim in almost every breach of contract claim, and that doesn't always fit, right? And I feel like a lot of them probably, and since we're on the bench, I can't say this that judges understand this, but I think there's some judges and certainly other lawyers that look at that and go, yeah, they do that every single time, and it dilutes the truthfulness of that claim, right? So you still have to prepare for it and deal with it, right? But some people just throw it in all the time, and I think when you do that, you lose a lot of
credibility.
Yes, that's a great term, Jim. You lose a lot of credibility in the marketplace. We include it some, but not nearly as often, even as we probably could, because you can always, if it develops and you find out from an evidence standpoint that it actually exists, you can always go back and amend it and add it, right? But it's just one of those things you don't want to always add that in to try to beat up the other side. So,
yeah, you need to do it when the situation's right.
Yeah.
Or they'll just get it dismissed or give you a Rule 11 sanction for filing a claim that you knew had no validity to it.
And one of the other things that people don't realize, that most people don't realize on the unfair and deceptive trade practices claim, the attorney's fee section. Let's say, for example, that someone sued your business and they were claiming unfair and deceptive trade practice. And if you don't have an attorney's fees provision in your contract, you can actually use this statute if they lose to hit them with your attorney's fees, which is nice, but not many people do that. So hopefully this is helpful to y'all. If you have questions, please let us know. We'll be glad to help you and reach out, try to answer those for you. We hope that, again, that you'll continue to use us as a resource. We do these to try to help people. And again, we hope that these webinars are helpful to you. If you're not linked in with us on social stuff, we'd be glad for you to do that. And Jim, it's always fun to hang out with you, man. Good to see you, brother.
Thank you all for joining us.